A very unusual story, I must say. Look at that. Kerala woman's plea to renounce Islam. You know, in a country where religion is often mixed with politics and for the advantage of politicians, this story is not only unique but reminds us that if we all adhere by that one book which rules us all, it is only the Constitution, Samvidhan. There is a plea submitted in the Supreme Court by PM Safiya, who is the General Secretary of Ex-Muslims of Kerala, a group who left Islam in the state and who wanted to be governed by the Indian Succession Act 1925 instead of the Shariat Act 1937, especially in matters concerning inheritance. Now, Safiya's plea is about seeking a declaration that those who did not want to be governed by the Muslim personal law should be allowed to be governed by the secular law of this country. There exists an earlier petition, of course, which is pending before the court, which was filed by the Quran Sunnat Society, to which Safiya is a party as well, demanding equal property rights for women. Now, according to the Muslim Personal Act, women are entitled to only half of what their male counterparts, could be siblings, could be a partner, gets only half of it. Safiya makes a distinction between the two petitions and said, while the earlier plea was for all Muslim women, the new one is for those who were born Muslim but wanted to leave the religion. The Supreme Court bench, comprising Chief Justice D.Y. Chandrachud, decided to issue a notice to the governments of India and Kerala, terming it a very important issue. As it's been reported, they requested the Attorney General to nominate a law officer who can assist the court. Both Safiya and her father are not practicing Muslims who have officially eschewed the religion. Safiya says in her plea, expressed her apprehension that if the same was applied to her only daughter, then her child shall only get 50% of her wealth upon her death, and the rest shall go to the father's brothers. Safiya also points out that even if she manages to get a no religion, no caste certificate from an authority, she will not be governed by the Indian Succession Act, and as such, her fundamental rights under Article 25 of the Constitution is made meaningless. Meanwhile, the Supreme Court bench has said that they will issue a notice to the governments of both India and Kerala. Like I said earlier at the beginning, this is one case where it has been reiterated that nothing really matters in this country except to abide only and only by the Constitution, the only book to follow.